right, counsel, did you have any comments you wanted to make on this one?
Just briefly, Your Honor, my client, and I don't know if Your Honor received the bench copy of my client's financial. This was the issue last week where it came over super dark. So I had hoped that if I provided you a colored bench copy that you'd be able to review those easier.
I did review them, but several
Okay.
of them are not legible.
Sure. Yeah. And I did see that Mr. Miller provided some pay stubs. So I think those are probably more accurate than the tax records that I was trying to provide. But nevertheless, my client did provide some pay stubs in addition to those tax returns. As you likely saw, the last pay stub she received in December, her year-to-date gross income was just over $68,000. In reviewing Mr. Miller's final pay stub for 2023, his year-end income was $102,000, nearly double the income of my client. So we are making the request again today for an order of spousal maintenance. My client is temporarily in the home pursuant to the restraining order, which was dismissed or denied on a temporary basis last week, given the kind of out of the box provisions that Your Honor had ordered. So my client is asking to be permitted to remain in the home. If you reviewed our motion, she is asking to remain in the home, and she's admitting to the fact that she would be responsible for, or acknowledging the fact that she would be responsible for maintaining the mortgage, the utilities, and the necessary expenses to remain in the home. She's just simply asking for some assistance from Mr. Miller, given the fact that he has been the primary financial breadwinner during the course of their relationship. So she is asking the court to allow her to remain in the home. She's currently in the home. Mr. Miller, throughout this litigation, has made it very clear that he has no intentions of keeping the home on a final basis. It's her request to eventually get to a point where she could keep the home on a final basis. So in order to kind of maintain the status quo and consistency, she is asking the court to allow her to remain in the home. Again, we brought up the issue of the cats last week. The parties do have 4 cats. Those are primarily cared for by my client. If she were to be forced out of the home, she would have to find housing not only for her, but 4 cats. Again, the financial status of the parties, Mr. has a lot more financial assets to work with. Again, also looking at our initial motion, my client is proposing he be awarded the motorhome, which I understand he took with him when he vacated the residence. So he does have that at his disposal. Obviously, he indicated in his pleadings that he works in Troutdale and is currently staying a little bit further north. Obviously, with the motorhome in his possession, the superior financial earning capabilities that he has currently, we do believe that it's more conducive and feasible for him to find alternative housing and to allow my client to remain in the home. That is our request for the court today.
All right, Ms. Petrie.
Thank you, Your Honor. Counsel is correct. The issues before you today, and they were kind of being weighed against each other at the last hearing, was whether or not who should have possession of the home and whether or not she'd be entitled to spousal support. With regard to the spousal support issue, we both actually filed financial declarations as well. Based on my calculations and counsel's numbers, his net income is $4,276 a month, and her net income is $5,643 a month. So that shows that she actually is netting more than he is. The idea of $2,000 in spousal support being requested by petitioner or by wife is ludicrous. I mean, that would leave him with about $100 a month to cover his food and, day-to-day expenses. If anyone should be paying spousal support based on the financial documents that were submitted, it should be her paying to him. So we are asking the court to deny wife's request for spousal support, and we are asking that my client be allowed back in the home. As we indicated in our responsive pleadings, there is a tribal interest in the home. My client does have an interest in protecting that. He may or may not stay in the house. He's willing to sell is what he has said. That doesn't necessarily mean that he won't stay in the house if it's awarded to him. But there is a separate property or a tribal interest in the house there. What wife is forgetting to tell the court or leaving out, whether intentionally or unintentionally, is that at her mother's house across the street, there is an empty apartment. The parties lived there before they bought their first house. So there is an apartment where mom can live. That is the most convenient. That is the most economical and logical solution for everyone. She says she wants to stay in the house, but if she stays in the house, then she needs financial assistance from my client. She can move out and move into the empty apartment at her mother's home and stay there, working out some rental arrangement with her mother, because she can't afford to pay some rent, and my client can cover the mortgage. So her arguments make no sense, and her request makes no sense in a long-term, from a long-term outlook. As far as the cats, my client, as he indicated in his supplemental declaration, has no problem holding on and taking care of the cats until she figures out where she needs to go. Although I'm not quite sure why she wouldn't be able to take them to that apartment. My client has concerns about her mental instability and wants to protect the marital home itself, property contained within. Back on the spousal support issue, my client takes issue with some of her reported expenses. There is already health insurance, and the idea that she's spending $1,000 a month in uncovered medical expenses is a bit extreme. She may be claiming her massages, but those are actually covered by the insurance. She's claiming $200 a month in crystals that she buys. I don't believe a cell phone line costs $370 a month. She's also quoting sewer and garbage fees as monthly when it's actually a bi-monthly expense. The cats do not cost $200 a month to maintain and feed. And she only uses, she puts in a fee for Instacart, but also puts in a fee for groceries. She's double dipping there. She never goes to the store. She only uses Instacart. So there's a double dip there that is inflating her expenses. So she can live on her own. She can support herself, and she can live in her mother's empty apartment. That is the most logical and simple solution to this entire thing. It also relieves my client of this extra commute that he is having to deal with by having to stay with family. I don't know about the motorhome, but it doesn't seem fair that she should get to live in a house and he has to live in a trailer. So, there's got to be some more equality here. Also, I would remind the court that this is a short-term marriage, and she is gainfully full-time employed and capable of supporting herself.
Counsel?
And Your Honor, just briefly, if you recall in the last hearing, wife made the allegation that Mr. Voluntarily reduced his wages to avoid a spousal support obligation. I think his pay stubs that he's provided for the court speak volumes. If you look, his year-end statement again was just over $102,000. To now say he simply makes $4,000 a month, the math just simply is not mathing. So I would ask the court to take that into consideration as well. Again, Mr. Aumiller's the only party in this action who's claiming that there's an option that my client could live with her mother. If you look back at his earlier declarations, he also indicates upon speaking with my client's mother that that living arrangement was not suitable long-term, that my client's mother did not want her residing in her home. So it is not an option. My client's not conveniently neglecting to mention that to the court. It just simply is not an option. What is an option is Mr. Aumiller has a motorhome in his possession. While it may not be fair or feasible long-term, it's a temporary resolution. And that's what we're asking the court to make today is a temporary order to determine where these parties can reside as we work through this divorce. Just lastly, as it relates to the cell phone issue, I would note that that is an extremely high dollar amount for the cell phone. However, if you do recall, there's been a lot of issues with the technology in this case, and my client's phones consistently being hacked. She has provided to the court that she's had to go out and get several different phone lines in order to avoid that from continuing. So that's just speaking briefly as to her expenses. She acknowledges that her expenses are high right now, but again, that's the style in which she's been accustomed to living. She acknowledges for the court that if she's permitted to remain in the home, she's going to trim the fat where she needs to in order to remain in the home and make sure that the expenses are paid timely.
Well, I look at the pay stub. It's got a net of $5,500 a month. I mean, it's 100,000 gross, but that's the gross. You got taxes out of that and union dues and all the other things. So net's about 55, which is more than I think he's listing, but and I I didn't do the math to figure out the difference on that, but it's not 100 that he's living on. And I had some real questions on the budget, frankly. I mean, the party's incomes, at least based on the declarations and on that pay stub, are not that significantly different. And I mean, even if I look at, they've definitely got lower on their financial declaration, but even if I look at yours, the difference is $800. So I mean, there's not a significant difference between the parties, even looking at that. So
and I would just note for the court, I don't know if it matters, but obviously Friday when Mr. Miller provided his pay stubs and his financial declaration, that's the first my client had any real access to his income information. Previously, it was guesstimates based on the documents that she was able to obtain from the household. So I do acknowledge, just from experience, that upon receiving this, our initial request does seem excessive. So obviously I'll defer to the court, but it is still my client's request for a order of spousal maintenance, whatever that it entails or amounts to, and that she is allowed to remain in the home.
Well, like I said, I mean, looking at the declaration your office filed, I mean, he's got $800 more, but he's also now driving farther. So I mean, and he's entitled to rent an apartment if he needs to. So, and
problem I see, Your Honor, is that she's making a representation to the court that she wants the house, but if she's going to stay in the house, she needs financial assistance. She needs spousal support. So considering the proximity of their income, the lack of need and ability to pay being established, I think it only makes sense that he should stay in the house because he can afford it, and she should be the one to rent.
well, if I look at her budget, she can't afford to rent. So, but I'm not sure this is a case with it. When again, looking at the budget that's there, that I've got some real questions about the numbers. I mean, I don't have a problem with staying in the house, but I don't know that, I mean, I'm not sure that there's a basis to order him to pay towards it. If she wants to stay there, he's got a cost of living. He's going to have to go out and either live in the motorhome and then drive. If he's driving to Portland, from Chehalis, he's going to have a huge increase in gas costs. She's working locally, correct?
I do believe it's just north of Vancouver. So it's also a little bit of a ways, but not as far as Chehalis to Troutdale.
Yeah, I mean, that's a lengthy commute. I don't know what they're driving or anything, but I mean, that's just that's going to be a significant. I guess my feeling is I'm not inclined to order any temporary support one way. If she wants to stay in the house and pay for it, that's fine. If she doesn't, then I can put him in the house and he'd pay for it. So I don't know if your client's present. I don't know if you want to talk with her about that, but I'm fine leaving her in the house, but I think she needs to pay for it if she's going to.
Mm-hmm. And I was able to speak with my client prior to today's hearing. She's currently working, so she couldn't attend, but I did speak with her before, and I did indicate that that's a very strong likelihood that Your Honor may indicate no spousal, and that if she wants to stay, she has to pay for it. And so she did tell me, and that's why I provided to the court that she acknowledges that if she's permitted to stay, she may have to pay those expenses, and is willing to trim the fat to make sure that happens.
All right. I mean, I think as long as she's willing to pay for it, I'll let her stay in the house. That's what and that seems not particularly unreasonable. Then he's got an extra $1,000 a month if he's going to live up there temporarily in the motorhome and drive. That gives him more fuel money. If he wants to rent an apartment closer to Hillsborough, that'll save him some fuel money. So, and I think based on the both parties' declarations as to their costs they've expended on attorneys, I'm not inclined to order temporary fees either way.
Okay.
So, assuming she wants to stay, if she changes her mind, she wants to move, and she doesn't want to stay there, then he would get the house and he would be responsible to pay it. So I'll give her first choice on that, her first option.
Okay, I can do that.
Okay.
And Ms. Petrie, do you think we need a presentation date, or I can just throw together an order, and if we can't come to an agreement, I'll just note it up?
Are you gonna draft the order?
I can draft it. Yes.
Okay, yeah, that'd be great.
Okay.
Thanks.
Thank you, Judge.
Right. All right, and you can just stick it on a docket presentation if you need to, so.
Very
Your
good.
Honor,
Thank you.
Tiffany Jensen,
You're
present for
welcome.
Heather Fontes.
Good afternoon.
Hello.
All right, I did have a chance to review through all the documentation on this case. So I believe this was Mr. Ball's motion.
Good afternoon, Your Honor.
Good afternoon. Excuse me. Oh, go ahead.
Okay, well, it's a motion for temporary family law orders. The primary issues are the parenting plan and child support. The court had made an inquiry at our last hearing regarding the protection order. And I just wanted to note for the court that in addition to my client's denials that he described in the declaration, that the petition for a protection order didn't list the child as a potential protected party. And there was the order that resulted from that hearing did designate some parenting time and deferred to this proceeding to establish a parenting plan. I think that's usually how these two types of cases are work together. Because the court can consider more information in establishing a parenting plan in this case. So I wanted to note for the court that Mr. Stemmerman had a pretty consistent, stable relationship with the child up until the time of separation. He filed this case soon after the protection order was put into place. But due to difficulty with counsel that he wasn't able to get into court until now. So he has consistently exercised the time, the 6 hours every Saturday since then. But he feels that there are some significant matters that need to be brought to the court's attention in establishing a temporary plan, which seeks really to kind of to change the residential parent. Your Honor, I think it's a good idea to appoint a GAL because there are a lot of he said, she said types of scenarios in this case, and it would be helpful if there was an independent investigation or someone independent to look into them to give the court some more guidance about what's actually going on here. So as I said before, Mr. Stemmerman had been routinely involved in the child's care prior to the separation. From the time he got home to work, he cared for the child and then had the bath time routine, a bedtime routine. I think everybody recognized that the child and the father have had a good relationship, and that the child is bonded with the father. Father also did some more supported the household by doing grocery shopping and cooking and cleaning as well. Mr. Stemmerman also supported Hadley's relationship with the extended family, his own, and mother's family. The mother had also supported Mr. Stemmerman's relationship with her own son, who is a little bit older, even prior to the time that Hadley was born. I think the court, Mr. Stemmerman wants to point out to the court that the significant concerns he has about Ms. Fontes's drug use and some of the, what he calls volatile behavior. So I think that he submitted some pictures showing supporting that she's a habitual marijuana user. She said in her reply declaration that she no longer uses marijuana, but she has been using marijuana. She even had a felony action against her related to use of marijuana. Marijuana use has contributed to her poor choices and causing damage to property, being volatile with Mr. Stemmerman and the children. Submitted pictures of property damage, kicking holes in the wall, damaging laptops. When they moved out, he said that there was broken glass over the property of his home, and there was a substantial amount of damage done there. Ms. Fontes was medicated for a mental health issue, and we believe that those things kind of create a risk of harm to Hadley, which is why primarily that Hadley should be in Mr. Stemmerman's care. Mr. Stemmerman has made an effort, not a complete effort, but an effort to address his sobriety. I think he understood that all the chaos that was happening with this case, and even the allegations that there could be allegations against him related to alcohol that led to a protection order. So he has not drank since, I think his clean and sober date was September 26, 2023. We recently submitted he took a hair test, an ETG test, and we'll supply that to the court, but it's going to have at least a 3-month look back to show hopefully the court that he hasn't been using alcohol. And so he's addressing that. He's made some lifestyle changes as well, like just working out and doing more hobbies, trying to eat healthy, really trying to address some of the things that needed to be corrected. He had been, again, very involved in the child's life, and he wants to continue to do that. He detailed a lot of things that were going on in the house when he got home. It sounds like both parties described the relationship as toxic. And so he's recognizing that. He recognized that as kind of the reason why they needed to end the relationship. So he was surprised that there would be a protection order issued. But he wanted to point out that Ms. Fontes had a history of making false allegations, and we submitted a news article where it was reported that she had made false allegations and was charged for some of those things for her conduct and statements made to police. Some of the other things is that Hadley has had exposure to, the mother's vape pen, taking pills, burning her hand on the stove, and being hospitalized and needing medical care for some of those things. Mr. Stemmerman doesn't have too much information about mother's current situation, like where she's living. I know that's protected information, but he doesn't know who is caring for the child, where daycare is, or anything like that. And so Hadley has lived up there in Cowlitz County at Mr. Stemmerman's house for some period, and would like to change that. I can understand if there were some type of transition plan put into place. The court should give us some timeline about if it does decide to appoint a GAL to come back and change the plan until there's at least a GAL finding. Ms. Fontes didn't file a motion to establish a temporary plan, just relying on the temporary plan that was in the protection order. And she said in her declaration that we didn't provide financial information, so she couldn't establish child support. But Mr. Stemmerman submitted a financial declaration in July, which is reports the same income that respondent says he makes. So they've had that information, but they've decided to just kind of rely on the protection order case, which I guess I understand. If there's any other questions, I think I pretty much addressed everything. I don't think there's anything else in the protection. I know the court had some concerns about the protection order and the relationship with this case, but so I'd like to address that if you have any questions, Your Honor.
I don't at this point. I did review back through that, so I've got both of those cases in front of me for information. I was aware of that at the last hearing. So, All right, so Ms. Jensen?
Thank you, Your Honor. Well, Mr. Ball has alleged a variety of things today and said a number of things, some of which I think are inaccurate. First of all, the protection order that's entered in this case does include the children. It's very clearly on the protection order on the very first page that both children are included, and that order was entered in June, I believe June 5th of 2023. Within that order, as Mr. Ball correctly indicated, there is parenting time for Hadley and Mr. Semmerman, and it's from 10 a.m. to 4 p.m. And he's been exercising that time, and my client has made sure that Hadley has participated in that parenting time. There was a domestic violence finding in that protection order that domestic violence had occurred against my client, Ms. Fontes, by Mr. Stemmerman. I'd like to note for the court that there is no motion for a GAL before the court, so I don't think the court can make any ruling as it relates to that. Should the court decide to move ahead on that issue, despite there not being a motion properly before the court, and if the court is inclined to appoint a GAL, Mr. Stemmerman should be responsible for the full cost of that. His request to change Hadley's primary caretaker, someone who's been her primary caretaker since birth. Mr. Semmerman worked. My client was the primary caretaker at home with Hadley, and she's been the primary caretaker since she fled the domestic violence situation that she was in while living with Mr. Stemmerman in May of 2023. She's been Hadley's primary caretaker. So his idea that we're just going to switch to a whole different residential parent seems a bit preposterous to me and really not in Hadley's best interest at all. He asserts my client has a bunch of volatile behavior and he submits pictures. My client has also submitted submissions to the court that show the condition of the home in which she left it. She denies that she put holes in the walls or left it a mess. And frankly, I'm not even overly sure it's relevant to the discussion that we're having as it relates to parenting time. Allegations of things that happened or that my client was accused of and or charged of doing years ago or in a newspaper article are also not relevant for what we're talking about today. My client has said in her declaration adamantly that she is not smoking marijuana, that she is clean, that she has a job that randomly tests her. She can't be doing that sort of thing. It seems that historically, probably both of these parties use substances to deal with the toxic relationship that they were in. My client chose marijuana on occasion, and Mr. Semmerman is an admitted alcoholic. He only very recently, as of September 26th, which is 4 months after this protection order went into place, did he decide that maybe he should get sober. My client's position is, Your Honor, that the current parenting time should remain in place until Mr. Semmerman completes an alcohol evaluation, complies with the treatment requirements, and also a domestic violence evaluation. Her supplemental declarations provided by family members who were present and in the home and witness to things that occurred show that he has a temper and that he needs to get that in check before having extended time with Hadley so that she's protected, make sure that she's safe. My client is agreeable to expanding Mr. Semmerman's parenting time per her proposed parenting plan once an alcohol treatment and evaluation is commenced and once a DV evaluation is commenced and treatment is complied with in that regard. She agrees that Mr. Semmerman should be involved in Hadley's life and wants him to have a positive relationship with her. And I think the fact that she has consistently made sure that Hadley goes to her parenting time with her father for over the last however many months it's been now, 7-8 months. And it requires someone from her family to do the driving and to facilitate that. And she's made sure that that happens. And that's been a sacrifice, not only for her, but for, her family members. So I think she should get some credit for trying to maintain that relationship. As it relates to the financial sides of things, Your Honor, I looked back through my file and I may be incorrect, but I don't see any financial declaration that was filed in July. Again, if I'm incorrect, I will in advance apologize, but I just reviewed my file and the only things that I received were a proposed parenting plan and a sealed birth certificate. So Mr. Ball's allegations that my client had all the information for financial child support figures, I believe is inaccurate. Nevertheless, we're here today, and my client would ask the court to adopt her proposed child support worksheets. They are consistent with what we understand to be the party's incomes. And then they also, of course, account for the fact that my client is the primary caretaker for Hadley and the residential parent. So we would be asking that those be adopted immediately and that child support at least begins January 1st, but we would also be asking that it potentially backdate to when Mr. Stemmerman filed this motion, which was in December. So at least extend back to December. In addition, my client would be asking that she be allowed to claim Hadley on her 2023 taxes, since she's been the primary caretaker for Hadley since May with no financial support from Mr. Stemmerman, since she removed herself from the domestic violence situation at that house. I think, Your Honor, unless the court has additional questions for me, that is our position. Thank you.
All right. Thank you. Just for note, there was a declaration filed along with the summons in the case, looks like on July 17th.
Thank you, Your Honor. I'll have to get that from the court record then, because I don't have that in my file. So, but I appreciate the confirmation and I'll make sure to get that.
Yeah, and it's unclear whether that was provided. It looks like your office accepted service on a number of documents, but I don't see that one listed. So I don't know if that was there or not, but it is in the file. It's got the identical number that was used in your worksheet. So I'm not sure how that came about, but all right, response, Mr. Bell? Any?
Just briefly, Your Honor. So some of this behavior is that Mr. Stemmerman has identified is relevant because it's taken place while Ms. Montes is in care of the children. And we're still concerned that that the statements she's making now don't really recognize maybe the addicted quality that we're describing. So so on occasion of using marijuana or no longer using marijuana or not smoking marijuana in the present tense doesn't really recognize that that she's taking a proactive effort to address that problem. My client says, and some others have said that it's a pretty significant daily use of marijuana, and using the vape pens and having that stuff available around the children is really what the concern is. I mean, I think there's something in there that there was driving while smoking marijuana with the children in the car. So in the GAO, I see my motion's not specifically requested, but both parties mentioned the use of a GAO. As far as Mr. Stemmerman doesn't object to the mother's income as reported by the mother. As far as the taxes, I think the child has resided mostly with Ms. Montes in 2023, so we'd ask that the taxes alternate every other year based on and also taking into consideration that the parent has paid child support up to the end of the year. And I also didn't see any information that the mother is taking random UAs or subject to random UAs, and I didn't see a date in there when she allegedly stopped using marijuana. So sorry to hammer Ms. Fontes, but thank you, Your Honor.
Okay. All right. Well, first off, I think the easy one, it looks like the child support worksheet that was filed January 4th by the mother appears to have the same, I mean, not objecting to the bottom line numbers there, the number that she's got for Mr. Stemmerman appear to be the same as in his financial declaration. So I will adopt the worksheet for essentially for all the purposes we use those for, including child support. And just one second here. It looks to me like initially in July 17th was a request for both of those things to be dealt with. My thought would be, instead of deferring this to a final hearing, would be to make that effective as of August 1. That would essentially cover any child support issues going backwards. given the circumstances, I would authorize her to claim the child for 2023. So in the current tax return, I'll defer on a final order of that until we get to a final hearing on this case. There's a lot of allegations that are obviously of concern in both directions. We do have a protection order, which was done after a hearing. It does include the kids on the order. I'm not clear why they were not included in the petition, so I don't know what authority there was to include those in the order, but they're there and that order has not been objected to, so it is the order of the case. I mean, it sounds like both of these parties had some significant substance use, at least back to when that all occurred. Both of them are saying they're clean. I don't really have a whole lot of proof of either. So what I'm going to order today is that each of them do today, if possible, no later than tomorrow, an actual drug screen, current drug screen, as well as a historical hair follicle screen. They'll tell me a lot. As far as a guardian ad litem, I don't have a formal motion. This is a case that's likely going to need one. And really two things. I'm not inclined to make any changes in the visitation issue until I have both results of those drug tests probably, I mean, I can either appoint our court investigator to look into this and get us back something in a few weeks, or I can appoint a guardian ad litem, which would be out probably a bit farther just because of the timelines involved. I think given the fact that there is a protection order that was granted, I think having domestic violence evaluation done would be appropriate, just simply because that's where we sit, and those are the facts before me. And I'm not making any judgments one way or the other about any of this. You both have asked to be primary parent. Both have made allegations in their proposed parenting plan that the other has domestic violence issues and substance issues. So we need to get to the bottom of that before the court's going to be able to make any kind of final decision. So that'll be the order. I want them both do a drug test today. If they can't accomplish that today due to some scheduling issues that happen tomorrow by, say, noon, that would give us reasonably good information. And then a hair follicle test, because that hair follicle is not going to tell me much as to what's happened recently, but it'll tell me something going back a few months. And he should sign up for DV evaluation and leaves visitation as is. I'm not saying that will not be addressed, but it very well may. Do you want to go with the guardian ad litem, or do you want to have our court investigator look into it?
I think a guardian ad litem would probably be most appropriate, Your Honor, to deal with all the parenting issues in the case.
Yeah, that probably makes sense. Who are our next three? Do we have a list here?
Beth Bellows,
So we got Beth Bellows, Karen Lawrence,
and Height.
and Ann Height. So yeah, you can strike one or none.
I don't have a preference, but go ahead.
I'm sorry to say, Your Honor, that I am unfortunately unfamiliar with any of those people, but I would defer to the court as to the court's judgment as to who might be best able to handle the particular issues in this case.
Well, we assign them in order, so there's no preference there. This is not a case, I mean, it's obviously a case that's got a lot of issues, but they're not particularly unusual issues, unfortunately.
That is unfortunate. Your Honor, could I just have 1 minute to confer with someone in my office? Thanks.
Sure, absolutely. And Mr. Ball, did you say you had anyone you wish to strike off that list?
I'm in the same position as Miss Jensen, except I don't have a phone call to make.
You want to call a friend?
Yeah. Your Honor, my preference would be Ann Height, please. And I see she's on the Zoom actually, so maybe she can confirm that she would be available and willing to handle this one.
Well, generally we go in order, so it'd be, you need to strike them, and then you're either going to have Karen or Ann, depending on what Mr. Ball does.
Okay. Well, then, Your Honor, I will strike Beth.
Okay.
That's we can go with Miss Height. That's fine.
So you need to strike Ms. Bellows or Ms. Lorenz.
I'll strike Miss Lawrence.
Okay, so strike Ms. Bellows, strike Ms. Lawrence, and we'll appoint Ms. Height as our next guardian ad litem to handle the case. This is a case where there's a lot of he said, she said, and there's, I think we should simply adjust the fees according to the child support worksheet percentages.
Okay, Your Honor, is there an order that the court puts together for the appointment of the GAL?
We
Or should we
generally
be
have,
doing that?
we generally have you do that, and those, we have a different, slightly different form than the state one. So if you go to our court website, you can download that form if you don't have it.
Okay, Your Honor, we'll get that done.
Yeah, I'm sure that somebody in your office has probably got it already, but that would be the one we want.
I'm sure you're
So-
correct. Maybe Mr. Ball could do the order from this hearing since it was his motion, and I'll do the GAL order.
That sounds fair.
Okay.
Is there, I know the court's been setting up a review hearing for the GAL report. We're going to set out a date.
We
and-
generally do that, and
Okay.
unfortunately, I haven't been doing this docket for a while, so do you know what our dates on those reviews are?
The compliance is 30 days.
Okay, so 30 days for the first review.
If you want an interim, 45 to 60 days, and then for the final 120 days.
Okay, so 30, I'm gonna do 60 days for the interim and 120, you said?
Yes.
120 days for the final, so that would be calculated from today. Anything else? I didn't miss anything. I think that was everything I saw.
I did have a couple questions. So
Sure.
you order the DV evaluation, is that for both parties?
This checks, I'm ordering it for him mainly based on the fact there's an order. I don't know that I have enough. Otherwise, if the guardian ad litem thinks it's appropriate, then we'll order it for both.
And then what is the start date for the child support?
August 1st, so it's a backdated order, but and that excuse me, apologize. That would not be since that order is being entered essentially as a back order, that is not considered as not being current on support so long as he's current going forwards. That's just a debt. If that makes sense.
So do you want like a money award in the order, or is it just going to say starting August 1st?
I'm not opposed to either way. You calculate the amount, we know what it'll be. It's not something that's going to affect any tax stuff or anything like that. So if you want to just do it as a judgment, that's fine. I just want to make it clear that he needs to be current going forward, but that the debt,
Okay.
the arrearage is not technically, he's not in arrears in the formal sense.
So current from January 1st.
Correct.
So if he's current from January 1st, 2023, then next year, when the
Be
court
current.
decides if he can claim the child for taxes, then we'll
Right.
look back at the
Yeah.
arrearage. Okay.
Yeah, I think that's, I don't think it'd be appropriate to make him in arrears if he hadn't in order to pay, so.
And is there a with the drug screen, is that a UA drug
UA is
screen?
fine. I'm fine with the UA or a swab, whatever
And is that addition to the hair test?
that is. I want both because they cover different time periods.
Okay. And my client I think he took one just Thursday or Friday. We don't have the results back. He
Was
didn't
that-
take a UA. He took, huh?
I think you said that was a hair follicle.
It was it was a hair follicle
Okay.
ETG test. Can he submit that so he doesn't have to incur that? It was like
I'm
$200.
fine with that. Council can look at it. If there's a concern on whether the test was appropriately done or whatever, we can revisit that. But if you did a hair follicle test that was done by a licensed agency, then I'm fine with
Was
that.
it
I just want both. I want the back one plus the current one.
So that was advanced diagnostics, and we'll provide that to the court and to the GAL and the party.
Right. And
okay.
those should be filed under seal, obviously.
Are there any instructions about where he can get a DV evaluation from? Or any other
I don't know that we have any specifics, but any state certified
states or fine?
provider,
Thank you, Your Honor.
you're welcome. As far as presentation, I can give you a date if you want to just be an upcoming docket, or if you want, or you can note it on if you can't agree, however you'd like.
Mr. Ball, I'll defer to you.
I think we should set it now so we can get it done.
You want it next week or 2 weeks or 3 weeks?
I think I need 2 weeks.
23rd?
Yes, Your Honor.
Okay.
That works.
Okay, 23rd presentation. If you do have an agreement on that and submit it, let us know. We can strike that date.
Great. Thank you, Your Honor.
All right.
Thank you, Your Honor. Okay.
Welcome. I believe that is our docket. Y'all have a good afternoon.
Thanks, Stephanie.
We will adjourn.